The council tax scam. How UK councils are quietly bypassing your legal rights. Across the UK, local councils are draining bank accounts, garnishing wages, and even threatening imprisonment, all without a proper court judgment. Sound legal to you? It's not. This all stems from the Local Government Finance Act of 1992, the law that introduced council tax. But here's the twist. That act never gave councils the legal power to enforce payments like they do now. No debt classification, no right to bypass court trials. So how are they doing it? Through minister-signed regulations, not full acts of parliament. These backdoor rules sidestep centuries of legal protection. And shockingly, they convert a legal duty into an enforceable debt without trial, without judgment, and without your chance to defend yourself. In the next few minutes, we're tearing this open, exposing the truth behind council tax enforcement, the legal sleight of hand, and how your rights are being steamrolled by regulatory shortcuts. If you believe due process still matters, keep watching. The truth about the 1992 Act. The Local Government Finance Act, LGFA, 1992 created council tax. What it didn't create is even more important. It didn't create a new debt class. It didn't authorize enforcement without judicial oversight. This wasn't a mistake. Over 100 years earlier, the Local Government Act 1888 made it clear, councils have no power to act like courts, administer oaths, or perform judicial duties. Section 79(2) says any legal duty of a county's residents becomes the duty of the council, but that doesn't mean councils inherit enforcement powers reserved for courts. That's because judicial power is constitutionally separate. Parliament may create statutory obligations, but the courts, not administrative bodies, are the ones empowered to enforce them. This distinction between administrative and judicial roles forms the bedrock of the UK's constitutional democracy. Modern enforcement, legal fiction. Today, councils enforce council tax as if a judgment already exists, leading to wage deductions, property seizures, even bankruptcy and imprisonment threats. But the LGFA only says you owe tax. It doesn't. Define it as a recoverable debt. Grant powers to seize assets without court trials. This matters. A liability is a legal obligation but not an enforceable debt until proven in court. A debt is enforceable only after judicial proceedings and a civil judgment. Without this safeguard, anyone could claim you owe money and take your property without fair trial. This isn't about whether council tax should exist, it's about how it's being enforced. Case study. Jane's story. Jane, a single mother from Kent, had a disagreement over her council tax bill. Despite disputing the amount, her wages were garnished without any trial. A liability order was obtained, she wasn't present, and wasn't given a proper chance to dispute it. Months later, she was served with a bankruptcy petition. When she finally saw a solicitor, she learned no actual court judgment had been made, just an administrative order rubber-stamped by a magistrate. Her case is not unique. The regulatory loophole. So where do councils get their powers? Enter the Council Tax Administration and Enforcement Regulations 1992, a set of statutory instruments. Cs. Not passed by Parliament, but signed by ministers. These regulations are not debated in Parliament, not subject to rigorous legal scrutiny, designed for administrative clarity, not legal overreach. Yet they created a shadow system where councils can seize wages, send bailiffs, force bankruptcies, place charging orders on homes, threaten imprisonment, all without proper judicial judgment. This means your rights are not being violated by law, but by regulation, a subtle but devastating difference. Regulation 49, turning duty into debt. Regulation 49 says, once a liability order is obtained in a magistrate's court, not a court of record, the amount owed is deemed to be a debt. Deemed, not proven. This fiction allows councils to pursue bankruptcy under Section 267 of the Insolvency Act 1986. Problem is, the Insolvency Act requires a real, proven debt. Liability orders are issued without a trial, based on unverified claims, processed in batches with minimal scrutiny. Expert view legal scholar Dr. Hannah Brooks from the University of London states, the use of liability orders to create enforceable debts blurs the line between administrative action and judicial oversight. It represents a dangerous trend in bypassing due process. Regulation 50, property seizure without judgment. Regulation 50 permits councils to place charging orders on property based only on liability orders without civil trials, evidence, scrutiny, judicial judgments, This directly conflicts with the Charging Orders Act 1979, which demands a proper court judgment. Case study. David's dilemma. David, a pensioner in Birmingham, had a small tax dispute that ballooned into a charging order placed on his flat. He was never given the opportunity to present his case in a proper court. By the time he sought help, he was on the verge of losing his home. Constitutional, human rights breach. Let's be blunt, this is not just a legal error, it's a constitutional violation. Historical documents protect you. MagnaCarta 1297. No free man shall be deprived of his property, except by the lawful judgment of his peers. Bill of Rights 1688. Bans fines or forfeitures without Parliament's approval. Modern law backs this up. Article 6, European Convention on Human Rights, ECHR. Right to a fair public hearing by an impartial tribunal. Human Rights Act 1998 incorporates the ECHR into UK law. Yet liability orders involve no trial, are approved without defence. Ignore adversarial legal norms. This regulatory system operates in the shadow of legality, exploiting technicalities to circumvent real justice. What the law requires. Charging Orders Act 1979 requires a court-ordered judgment. Insolvency Act 1986, Section 267, requires a liquidated proven debt. Neither is satisfied by a liability order. These are administrative shortcuts masquerading as legal authority. What you can do. If you're being targeted, request a full court judgment. Don't settle for a liability order. Challenge bailiff action. Ask to see their legal authority. Write to your MP. Demand parliamentary review of council enforcement powers. Submit FOIA requests. Ask your local council how many liability orders they processed in bulk. Consult a solicitor, especially one with experience in public or constitutional law. A message to public servants. Council officers, solicitors, and enforcement agents. You swore to uphold the law, not sidestep it. Continuing to act on these regulations, knowing their constitutional flaws, may expose you to misfeasance in public office. Breach of solicitor duties. You serve the public, not ministerial convenience. History has judged those who blindly followed unlawful commands, and it will judge again. FAQQ. Is council tax illegal? A. No, the tax itself is lawful, but how it's enforced may be unconstitutional. Q. Can I ignore liability orders? R. Not safely, but you can challenge their validity. Q. Has this been taken to court? R. Several cases have raised the issue, but more public pressure is needed. Q. What about Scotland or Wales? A. Similar systems apply but with regional variations. The core issues remain. Q. Can I refuse to pay council tax? A. Not legally, but you can demand enforcement through proper legal channels. Council tax enforcement today is not just flawed, it's a quiet constitutional disaster. This isn't about avoiding tax, it's about defending your birthright. Due process. Stand up, speak out, demand your rights. If this opened your eyes, share it. If you want justice, subscribe. If you're ready to challenge the status quo, act now, because the Constitution doesn't protect itself.